Welcome to eDiscovery Leaders Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal-Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in. Good afternoon and welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha, Senior Vice President of Brand Awareness at Reveal. Typically, each Friday morning at 11 a.m. Eastern, I host an episode of eDiscovery Leaders Live where I get the chance to chat with luminaries in eDiscovery and related areas. Obviously, it is not Friday morning, 11 a.m. Eastern. We are broadcasting this week live from ILTACON in National Harbor, Maryland. This is the third interview today with 11 more to come through the course of the week if all goes well. My guest for this episode is Linesh Maharaj. He is a director within the Applied Legal Technology Group at King & Wood Mallesons, based in Sydney, Australia. His main area of expertise is in the execution of large-scale document review projects for discovery, arbitrations, and other regulatory requests. During his time at KWM, he established the firm's managed document review offering and transaction support team, both being... Okay, I'm getting confused here. You're going to have to explain what you've done. Forget me doing this. You're going to do this. Linesh, what have you done at KWM?
Thank you, George, and pleasure to be here today. In my time at KWM, I sort of initially set out to run large-scale e-discovery matters, as it says on the label, as to what I do. But it became sort of evident early on in my time at KWM. There was a lot of growth happening within the sort of e-discovery space. And as tends to happen in these firms, our focus ends up being on the litigation side of the business. But King & Wood Mallesons is a very large transactional firm also, and we wanted to provide the same level of technology support that we provided to our litigators to our transaction practices. We have a very amazing innovation team that would go out and identify these cool technologies that they'd want to bring to the business, but there was no one really to pass that on to once they had already experimented and tested out these products. So we established a little team that basically commercialized and productized these offerings within our firm. We identified where they could be of use, identified new case studies, and then basically tried to support the adoption of these new technologies in our firm, predominantly in the transaction space, because our e-discovery offering was right up there and pretty well established.
So I think I probably have a pretty good idea about the broad parameters of your e-discovery offering, but
yes,
not at all about the transactional side. So what are you offering on that side?
On the transaction side, I think the industry has advanced quite a bit in the last sort of 5 to 10 years. Obviously on the e-discovery side, it's been a lot longer, but a lot of contract AI type technology. So particularly in the due diligence space, where you're reviewing effectively the same kinds of documents, and the old-fashioned way was to get your junior lawyers to sift through and identify relevant provisions and then extract that output into a table, which is very manual, very laborious, and very costly when you look at the cost of a mid-level sort of lawyer doing that work. So these tools and technologies have a very high accuracy rate. Especially where you're dealing with standard form contracts and you're extracting the same kind of information. So we roll that out within the firm. We also have technologies that help with deal verification documents. So it makes that process easier, a lot of collaboration tools. So it's fairly wide ranging, actually.
Yeah. Well, that's impressive. I'm not sure I've heard folks talk about that side of the business so much. I mean, I tend to hear about e-discovery, litigation, investigation, We don't have folks talking about the transaction side so
Yeah,
much.
and what's fantastic is as we use these other products more and more often, we find use cases that actually help us in the discovery side also. So when you're looking at some of these technologies that can compare multiple versions of documents side by side, it helps us to examine witness statements, how they've shifted from a draft witness statement to a final form witness statement, for example. Or if you're looking at a technology that we use in the deal verification space, where you're boxing up statements to get them verified by a third-party collaborator. So you think of the case of a financial statement by a company, you need to get a paragraph verified by the CFO to say, hey, is this accurate? You take that same piece of technology and you apply it to the opposing side's expert reports, and you say, here's 30 paragraphs in an expert report. I want this paragraph to be verified by my expert. Or I want that paragraph to be verified by, my key witness. In the old-fashioned way, you may email that same document out to 5 different people. You're then chasing up the 5 people to get their comments. You're then trying to stitch it together. Whereas this is through an online piece of software. You can track your responses. You can add supporting documents in and attach them to the paragraph. So we try to.
Interesting.
Yes.
In 20 years as a testifying expert,
Yeah.
I never knowingly encountered anything like that. I never saw that level of sophistication either with the attorneys I was working with or with the attorneys on the other side of the matter.
Yeah, it's been a lot of it is through trial and error, and one of the things we do as a firm is to try and ingrain the technology through our graduates. So we want to get to them early. So as part of their sort of induction and their first sort of year of practice, we take them through these technology boot camps, and these are really smart, bright individuals who come up with some of these use cases by themselves, and we then test them, sort of verified, go, yeah, actually, that's a fantastic idea. And then we then say, well, if it works in that scenario, then surely it's going to have applicability in this scenario. So quite often we create Frankenstein's monster. But more often than not, there's an inherent time saving. There's accuracy that we wouldn't have otherwise seen from a manual process. So I think one of the great things, particularly at KWM, is that sort of culture of trying something new and trying something different.
Laudable. You say we. How many is we?
In the broader team.
Yes.
So in terms of our applied legal technology team, I think we grew from a team of 5 about 4 or 5 years ago to having a team of about 27 now. So exponential growth on the back of a lot of regulatory work that was happening in Australia at the time. Teams were getting stretched. We had data security concerns from our clients, which meant that we had to do a lot more internally. And when we started doing more work internally, there were also pressures to sort of work across the whole EDRM and do more than what we traditionally would have when we looked at what we did 5 years ago. Also, the growth in that sort of transaction side of our business and all these new wonderful technologies coming out meant that we needed to have people who were, in effect, product managers who could support a product through the organization. So that led to a lot of growth in the team. So from my opinion, I think some of the mistakes that organizations make is bringing in a technology but not having a product manager or a champion supporting that product, because often we deal in situations where lawyers are under pressure to get something turned around or to get a deal done or to get a production done. Sometimes they don't have time to want to test something out because of fear of it going wrong, and go, well, I can't miss my deadline, so I'm going to just revert to what I know and what I'm comfortable with. Whereas if you've got a champion in the organization who is across the product as well as across the business and can sit between the lawyer and the technology, I think that sort of fosters that growth and almost puts that comfort blankets around the lawyers. It also gives the lawyers more comfort in presenting to clients when you've got somebody who has a handle on the technology. So one of the things that we also do is if we're presenting a piece of technology or a solution to a client, it's often not just the technology. We don't just go to a client and say, well, we've got this great piece of technology.
We got a bright, shiny object.
Yeah.
Doesn't it look wonderful? Right.
Exactly. It's the client couldn't care less ultimately about the product, but they're really intrigued about the solution. And that solution is people and technology. It's not just one or the other. So when you're bringing that thinking to a client, or you're presenting to them that you've looked at their issue and you're coming up with a tailored solution, and like I said, often it can be Frankenstein's monster, but you are presenting an option to them, which is not the traditional way another firm would approach it. I think that always puts a positive light on what you're doing as an organization.
You must then have a diverse team in terms of background, areas of expertise, and the like.
Yeah, we do. One of my team comes from a completely product IT background. Had never worked in a law firm before. He'd sort of dealt with legal products before, but this was his sort of first journey into law firms, and his skill set has been amazing in terms of the commercialization of these tools across the practice, because these products are all very expensive. The firm, whilst there is an investment in technology, you're looking at ways to have a return on the investment, whether it's through a cost recovery model or whether it's a profit model. So coming up with novel ways of pricing has been invaluable, looking at how he approaches the size of the market, both internally as well as what the external potential is. So that's the skill set we traditionally wouldn't have had within our team in a law firm. I'm sure we've got pricing people who are probably more used to the legal side in terms of selling hours and what billable units look like. But in terms of these products, where some are charging on a per gig basis, some are charging on a per doc basis, some are charging on a per hour basis.
I know from past experience, trying to figure that all out is no mean task.
No, and it's not only factoring in the price of the tool from a licensing perspective, you also have to factor in the cost of the support of that tool. And when I talk about the cost of support, it's not just archiving data or uploading data. It's actually spending time to come up with the case studies, spending time on presenting internally, spending time on training. So all of those costs are kind of, to an extent incorporated into how we come up with a pricing model. Because often when you look at it purely from a licensing perspective, all those other costs can be forgotten about. So the true cost of bringing a product into a law firm can be
much
lost.
greater than just what you pay for.
Oh, massively. Massively. Yeah.
You mentioned data security.
Yes.
That's got to be a increasingly important issue.
It is from a number of perspectives. One is what we've just touched on. When you're bringing in all these new different technologies into the firm, it's wonderful that you can have a wide range of products that you can put together as a solution. But with it comes, more risk of security breaches or clients wanting comfort around what security audits you've done. How confident are you with where the data resides and what security controls those companies have in place. So, because ultimately it's the client's data that's sitting on those servers. It's not the firm's data as such. And I think when we look back over the last few years with the increase in ransomware and legal service providers being affected by ransomware, clients want to mitigate the risk of their data sitting in multiple locations. So with that, I think has resulted in this sort of increased awareness of where data resides, and sometimes clients want it to reside only at one point or one degree of separation from their organizations. They don't want it to go to a vendor necessarily or to a third-party organization. It's been a huge concern.
So without getting into details that you shouldn't go into,
yes,
what are you able to do to help ensure or increase the chances that the data is as secure as clients hope it would be?
I think there's always, there's always a risk of something happening. No organization is immune from any sort of cyber risks. But we've invested as a firm heavily in our information security. team, which has probably grown exponentially over the last few years. So whenever we're taking on a new product, it goes through a rigorous security audit. MSAs are in place with those vendors also. And ultimately, prior to using any of these technologies on a client matter, we seek express consent from the client. Sometimes the client wants to get their own security team to look at these technologies, and particularly for our larger clients where we use a wide range of tools, whether it's a litigious matter or whether it's a corporate deal that they're working on. So we may deal with their cyber teams or their information security teams at a firm-wide level to get them comfortable with all the technologies we're using. Sometimes we've got clients who say we don't have time to go through that approval process. You're going to have to do this work internally to the extent that you've got tools that are on-prem that aren't in the cloud.
Right.
Because sometimes turnarounds are really tight and they don't have time to go through that sort of
So you need that flexibility to be able to run tools both in the cloud and on-prem, I gather.
Absolutely.
Yeah.
Particularly with e-discovery, we've seen a shift. Traditionally we would engage in master services agreements with third-party vendors because the quality of the work that they were providing to us was at a very high level, economies of scale in terms of pricing. So, but as that sort of security posture has changed over the last few years, we're seeing some clients preferring the firm to do that sort of work internally, particularly if they're sensitive documents. If we're doing work for government agencies or other highly regulated industries, a lot of that data, cannot leave the firm. So that's meant that we've had to invest significantly in people, in technology, and in security to support that function.
Yep.
Which has been onerous at times, but also when you pivot that, you actually get a lot of opportunity that comes out of it.
Yep. I would remiss if I did not ask. I understand you worked on the first TAR case in Australia.
I did. It was a while ago now, but it was, I think, if I go back probably around 2015, 2016, it was sort of coming off the back of a few of the early TAR cases in the US and the Irish Bank case in the UK. It was a sort of a construction litigation matter which involved a repository of around 4 or 5 million documents, which ultimately resulted in documents being produced of the region of about 1.4 million documents.
Okay.
Because it wasn't, in terms of the proportionality discussion, it just was never ever going to be cost effective to review 1.4 million documents, which was after searching and culling had already been done. The documents were disclosed to the other side, warts and all, in the 1.4. They sort of said, "This is too much. You haven't."
Right,
you haven't fulfilled your
data dump.
Correct. You haven't sort of fulfilled your obligations, and there was an argument around the proportionality and a lot of toing and froing, as you can imagine. But ultimately, the Victorian Supreme Court, held that predictive coding was appropriate for this particular matter.
So did they hold that it was appropriate? Did they tell the parties you must do that? You must do that, or you may do that?
It became a must do that because clearly manual review of the 1.4 million documents from a time perspective and a cost perspective was not appropriate. So predictive coding, which hadn't been ordered in Australia before, was ordered by the court in this particular instance. The nuances of this case were that the 1.4 million documents were already in the possession, had already been disclosed. So the other side already had the 1.4 million documents. So what was strange about this particular matter was that as part of the TAR protocol, there was a collaborative review of the documents from a training perspective.
I don't think I've heard of that before.
No, exactly right. And that process is it was the first time I think anyone had done it, and I think the reason why it was ordered was, like I said, the other side already had the documents. So when you were generating your random sample, for example, the review effectively involved three lawyers sitting around a table, pulling up the document, saying that's relevant, that's not relevant, that's relevant, and as you can imagine, it was not uncommon for one lawyer to say, no, that's not relevant, and the other one to say, yes, it is. And it was kind of a 2-to-1, if two people thought it was relevant and one person thought it wasn't, that document was coded in accordance with that. So that was an interesting process. Where there was difficulty in that process was, and I think we had this sort of discussion just before, you'd have a particular type of document in sort of training set number 1, which was coded a certain way by all three of the lawyers, and then in training set number 3, 2 of the lawyers say, oh no, that's relevant now. So
better than I was. Huh?
And you looked at the same document, like it was a daily report or a weekly report, which was exactly the same in content, but across 6 or 7 rounds of training, that document had been coded as relevant, not relevant, not relevant, relevant, relevant. So that I think proved difficult, because if 3 senior lawyers don't know how to code a document or aren't coding a document consistently, your precision ultimately suffers in terms of your review, and also the speed at which you could review a set of documents would be weeks, because you'd have to wait till all 3 parties review the documents. You then have to have a discussion over it. So whilst it was a fantastic learning experience working on that matter, I wouldn't have regarded it as the best example of a predictive coding matter in the country.
Yeah. How did, when they had that type of issue come up, how did they resolve that?
There was an independent referee who was appointed by the court, a special referee, who would then sort of adjudicate on some of those decisions. Okay. But ultimately, I think in that particular matter, despite it taking a long time to go through that process, it still resulted in that population of 1.4 million documents being reduced to something like about 250,000 documents.
That's a big difference.
And I think it was like 80% recall. So it did work out well in the end, and it highlighted, despite the fact that there can be some disagreements as to how documents are coded, ultimately the technology was still able to cull around 1 million documents or over 1 million documents quite successfully.
What other lessons were you able to take away from that experience?
Never do a collaborative review.
Okay. Since it's the only one I've heard of.
Look, a lot of lessons from that particular review, but I think consistency as to coding particular kinds of documents, I think is obviously imperative if you want to try and enhance the efficiency of any sort of predictive model. A couple of other things through that matter, and in subsequent matters that we run, it's really crucial that people reviewing your sample set, for example, are the same people that are actually doing the review. There's no point having senior SMEs doing a random sample and then not touching the rest of the review, and you're outsourcing it, or you're using junior lawyers, because you're going to get a misguided rate of recall, because sometimes your junior lawyers are more overly inclusive, so you think you're getting to the finish line a lot quicker than what you actually are. So ensuring, I think, just being consistent across how you're treating your samples versus how you're treating your actual review sets, whether it's in a CAL review or whether it's in a predictive coding review, I think is imperative.
Fast forwarding then to today, how common or how unusual is the use of tar in Australia?
I can only really sort of speak to our practice, but it's part of our day-to-day practice, whether it's to undertake a review from start to finish, whether it is just to do a form of QC on stuff that's already been reviewed, or if it's used just to identify very specific documents relating to a specific issue. So we try to use some form of CAL or predictive coding just to enhance any review that we do. I'd say, very common.
So one last question in the, or a set of questions in the 5 minutes or so remaining.
Yes.
We had a little thing called the pandemic.
Yes.
What sort of impact has that had?
It's had some positive and negative impacts. I think in terms of the positives, I think people adjusted very, very well to remote working, and in many ways working as e-discovery or practice support, technologists or practitioners. I think sometimes that's a remote working environment can be more effective for us, because often we're working late on productions, or we're having to wait for lawyers to sign off on a particular piece of work, or to undertake further review. And often the team was waiting around until 8-9 p.m. just for a lawyer to get back to them before they could hit the go on a production.
Right.
So that meant spending a lot of time in the office, where otherwise they could have been doing something at home with their families. So we actually found that people were getting a lot more work-life balance. Yeah, they were still working long hours, and they're still working very odd hours, but at least they could sort of balance that out. If they were waiting for something, they could have dinner with their family, for example. So
Yes.
that was positive. In terms of the commute, a lot of people were having to commute an hour and a half into the office each day. Instead, they were logging on to work. Wouldn't say a lot earlier, because that's can be unhealthy also. But they didn't have the same stress and anxiety of having to get into the office, having to get kids dropped off at school, etc., or to have to rush off to pick them up. So we felt that our staff were a lot happier, and that resulted, I think, in them being ultimately sort of more productive in their day-to-day jobs. Where I think it's probably been potentially less ideal is probably in that sort of training and mentoring piece. Particularly, as I say, the team has grown considerably in the last few years. So when we're taking on junior staff, I think that day-to-day knowledge transfer of working over someone's shoulder, or seeing visible cues of confusion or distress or anxiety, it's a lot harder to ascertain on a Zoom call, or at times if you wanted to reach out for somebody to help you in the office, it seems to be a lot easier and more convenient, rather than having to think, okay, I've got to see what that person's doing, got to call them, I've got to reach out to them, I'm just going to do it myself. Tended to be kind of that sort of default position. So I think knowledge transfer and that internal networking and the culture has probably shifted slightly, not necessarily for the bad, but it's just a bit different.
How many of these changes persist, and how many situations have you fallen back to prior practices?
I think broadly as a firm, we've definitely altered the way that we're working, and the firm has been very supportive of that change. We generally would average 2 to 3 days in the office. Some people would do more, but I think having that sort of glue day where everyone is coming in and or having a set roster in effect to say, hey, these are my 2 or 3 days from the office, I think that's helped, because if you wanted to catch up with somebody, or if you're working on a project with somebody, you knew that they were going to be in the office on those days. So we tried to put some sort of rigor around that, because otherwise you'd come into the office hoping to meet up with a particular lawyer or a particular person,
and there's no one
there's no one there. So despite your good intentions of being in the office, it could prove futile if no one else was there, or your team wasn't there. So
Well, Linesh, thank you very much.
Thank you very much.
Linesh Maharaj is a director within the Applied Legal Technology Group at King & Wood Mallesons. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. Linesh, thank you so much.
Thank you, George.